Hello, my name is Raed Jarrah, and I'll be presenting the study that I did with my co-authors Qasim Korkmaz, Sulaiman Ashur, Thomas Kiernan, and Banu Kulak on a comparative study on dispute resolution in industry and the departments of transportation in the United States. Do all the preemptive actions not to get to the level of a dispute, communicate earlier, discuss issues before they escalate to the level of dispute, but eventually things do reach to the level of dispute. Whereupon the next level in dispute resolution would be negotiation. This is defined as two parties sitting together and amicably finding a solution that they'd be willing to both compromise on. The problem, though, is that sometimes negotiation is not as amicable. So therefore, you need somebody to referee or to coach the parties on how to reach an amicable negotiation. This would be the mediator's role. So a mediator would step in and act as a facilitator between two parties to encourage them to reach a compromise. The mediator does not make a binding decision. They may, at the end of a mediation session, provide a set of recommendations or propose a solution. The next level after that would be a dispute review board. So this would essentially be an internal tribunal within the project's client organization. But as you can see, with all these levels, we haven't reached to the level where parties are actually forced to abide by a decision which is made by the others. Now, just keep in mind, dispute review boards may force a decision, but that decision may still be appealed through either arbitration or litigation. Now, arbitration and litigation are not consecutive. They're branching alternatives. You either go into arbitration or you go into litigation. The reason is because arbitration and litigation are both binding decisions. So whatever the judge decides or whatever the arbitrator decides, you have to stick with. So as a problem or dispute escalates from the early stages onto post-claim, the costs and the hassles associated with resolving the dispute increase exponentially. So while you're still disputing the issue within the project, it might be easier to resolve it internally than getting other parties involved. And mediation at that point is getting a third party, but just to coach you on how to work together or how to facilitate between the parties. So let's take what would happen, though, if you have a claim with a Department of Transportation. So in this case, we're going to take the Michigan Department of Transportation. What they would require contractors to do is to file a claim. And they have the different time periods and notice periods for filing those claims. So as any normal claim, the contractor will first pass it internally within the project organization to the engineer who would make a decision. They disagree with that engineer's decision. They raise it one level up to the Michigan Department of Transportation's regional office for review. Then it goes again into a decision. And if the contractor decides to appeal the regional office's review, well, they do have another chance, which is they take it onto the next level, which is the central office's review. So this is the office that's higher than the regional office. And they would take a look at the claim. And after that process has been exhausted, if the contractor still does not agree with MDOT's decision, Michigan DOT's decision, well, in that case, their next option would be to follow further legal action, either by taking it to litigation or arbitration, because at this point, it's gone through the claims process and to no avail. In this study, we've taken a look at 10 of the largest departments of transportation in the United States of America, and we've ran a comparison between what are their laws regarding dispute resolution, what do they require you to do, and these 10 states were basically picked by the 10 largest departments of transportation. So the largest one we start with is California. The thing is, with California, you have the option to go with arbitration or litigation, but if the contractor fails to follow the process for the claims procedure, they would be barred from forcing or asking the California Department of Transportation to go into arbitration. Their next option would be to go directly into litigation. So in California, in order to retain your right to litigate, to arbitrate, you must first of all follow all claims procedures. In Texas, there's more options there. You are free to go with arbitration, mediation, arbitration, or litigation. It's just that mediation and arbitration are encouraged ahead of litigation. In New York, generally speaking, the state does not like to be forced into arbitration, so most of the DOT contracts do not allow for arbitration. In Florida, instead, it forces the contractor to go through the Florida Arbitration Board. So this is kind of like a combination of dispute review board and an arbitration, where the arbitrators are from Florida's representatives, so from the Florida DOT's representatives. So this may seem a bit unfair, but the thing is, the courts are already on the state level and the federal level very backed up with court cases that a lot of state and federal agencies do encourage arbitration. Only in this case in Florida, it's more leaning towards their side. In Illinois, the state gives the option to go into arbitration, but with the decision of both parties, the DOT and the claimant. They will not allow themselves to go into a contract that forces them into arbitration. So they want to retain the choice of arbitration. In Pennsylvania, like Texas, gives you the option of arbitration or litigation. In Ohio, arbitration should be mutually agreed, or if there's no mutual agreement, you can go to a court of law. Notice the difference here between the language of Ohio and Illinois. So Illinois goes by the idea that we shall not be forced into arbitration, whereas Ohio words it that if we both agree, we'll go into arbitration. Otherwise, we'll go into litigation. Washington states that there has to be a process that goes through their dispute review board before you go to arbitration or litigation. Georgia requires that the parties mutually agree, like Ohio, or by court of law, and so does Colorado. So there are some issues with arbitration that, first of all, the costs are not necessarily cheaper than litigation because the public court is funded, whereas arbitrators will charge fees. Now, the parties still need to hire their own legal counsel either way. Arbitration, though, tends to de-emphasize legal principles and evidentiary rules and standards and procedures. So you tend, in an arbitration case, to accept more evidence and just, even flimsy evidence. And this may lead to prolongation of the arbitration process. The thing is, with litigation, the process of appeals is more straightforward. You have the courts of appeal, and then you go to the one higher level and up to the Supreme Court in the United States. But in arbitration, appealing tends to be very limited and has a lot of conditions to be allowed. And still, our courts are still overburdened, so arbitration is tending to be a preferred approach here. Now, unlike courts and court cases, in arbitration, if you have two parties who pick the arbitrators but are now involving third parties in their disputes, those third parties didn't have a choice in picking those arbitrators, and this might tend to lead into some complexities. So what we can conclude from this study, though, is that there's still a lot more to do, primarily on evaluation of the costs and duration of arbitration and litigation when it comes to departments of transportation, and what are the outcomes that are coming out of cases that are being arbitrated by contractual requirement, or where the parties were given the choice to go to arbitration or not. So this is more further areas for exploration on this topic. Now, thank you all very much, and I hope you enjoy the rest of the conference.